Saturday night.
Are we online?
Yes, we are.
Yes, we are. This is the bill on forfeiture. Is it not?
Yes.
Civil forfeiture. Hopefully we fix this mess. Draft 1.3.
Yes.
That's everybody's best guess. Oh, you want to go over the differences? Or
Will,
is the whole thing completely different?
the whole thing is completely different.
Okay.
So just to, and I can go ahead and share my screen, so it's up there if you'd like, Senator Sears.
Yeah, we've all got copies here, but maybe some of the witnesses don't have copies. Is it on our webpage?
Yep.
Does anybody need the screen shared? Okay, go ahead, you shared it, so let's go.
Okay. So good morning, Ben Obergrosky, the Office of Legislative Counsel. Senator Sears, as you said, this is draft 1.3 of a strike all amendment to House Bill 533, which is entitled an act relating to converting civil forfeiture of property and drug-related prosecutions into a criminal process. If this bill or this amendment is adopted, that name will no longer apply. What this bill does is essentially revise the current civil process in an attempt to make it more workable and usable for the courts, law enforcement, innocent owners, lien holders, and defendants in related drug prosecutions. I should say, sort of before we dive into the details of the bill, that
Can I have a
I have to give gratitude to Chief Judge Zone, Evan Meenan, Tucker Jones, Sheriff Marku, for really diving in on a relatively short time frame to try and make this workable and a version that could be worked with. You know, it's not a small task to try and revise a whole court procedure in just a few weeks. So I just wanted to express my gratitude to them for their contributions. But with that being said, I think it's good to kind of put this in context a little bit about what the sort of inspiration for the structure that this bill does. So if the committee is familiar with the civil suspension process of licenses related to DUIs, that serves as a loose inspiration for the structure here. And for context, what normally happens with that, when someone is cited for DUI, they're also given a set of documents at roadside, or they can be mailed to them, essentially providing notice that the MV intends to suspend their license, and then they have the ability to request a hearing to contest the suspension. What that does is kick off a parallel civil process to the DUI prosecution that can oftentimes run parallel with the criminal prosecution. And that's what this process attempts to achieve as well, where if someone's property is seized, when they are provided notice, the notice will contain a pack of documents where they can request either a post-seizure hearing and a judicial determination of the forfeiture. The state will be the entity that has to provide a petition of forfeiture, which would start the process, and then within that process, the individual can request those hearings. If they do not, they essentially default, and the forfeiture and the state will gain title to the property. That is the general structure of this process.
So that we all understand that a drug dealer gets caught, it's arrested, charged with dealing drugs, and has $25,000 in cash. The state could then start a process to put forfeiture to seize the $25,000.
Essentially, there's, and this is why I said it's loosely inspired. There's some machinations within the investigatory process and seizure that are built in that I'll get into, but by and large, it would give law enforcement that ability to file the petition, and then once they notify, what I'm going to refer to as the interested people, they then have the ability to request those hearings to either seek temporary return of the property while the forfeiture process plays out, or just to have a judicial determination of the forfeiture alone and ultimately seek return of the property permanently.
Thank you.
So with that, and I should say that that's the overall structure, and there's still ongoing discussions about specific language to ensure it's workable. So, I do want to just say that there's still feedback coming in, but overall, I would say it's safe to assume that the overall structure as it's outlined is there.
How does it work with the co-owner here?
So
Of cash, I mean,
Well,
is that going to explain that? to
go
you?
ahead, that's the first change.
yeah, so in 4241A, this was not initially in the bill. This was something that disregards the scope of what is subject to forfeiture in the subchapter. The additions here on line 21, and if you look later on page 2, line 2, of co-owners, really to try and be consistent with the usage throughout the whole subchapter, where it's not just owners, it's also co-owners. As far as how it would play out specifically with currency, that, I think that would be a good question for law enforcement, but typically, if you're looking at securities, there can be people that are beneficiaries, but really when it comes to cash, my understanding is that there's really just one person.
I'm thinking they search the house. They come, they arrest, come to a house, arrest somebody at the house, search the house, get a search warrant to search the house for drugs and whatever else.
Mhm.
And they find cash in the dresser drawer. So, say this is a guy, woman living there, says it's my cash. They're seizing it anyway, right?
Right, and then they would be the owner of it.
Might be helpful to go through the bill and try to understand how that works.
Yeah, and as far as these specific questions, these are some of the considerations that are still sort of under contemplation to get the language just right.
All right.
And so with that, going from page 1 to page 2, there's the addition of co-owner. On line 4 and 5 of page 2, there's the addition.
Ben, sorry, on my screen, the draft is not advancing as you're going to page 2.
Thank you, Senator Ruth.
Too many things to do all at once.
There we go.
Yeah, thank you. So here there, on lines 2 through 5, there's a clarification on derivative proceeds. So these would be derivative proceeds from perhaps the sale of drugs or something like that. And it does not include real property which is occupied as the primary residence of a person involved in the violation of the drug violation, and a member or members of that person's family or domestic partner. This language specifically is still under discussion about how restrictive that could be to law enforcement. Essentially, there's the situation of the bad landlord and the previous testimony that's been given by Evaminen and DPS, where you may have someone that claims that a house is their primary residence, but maybe they're really just a transient that are here to at the behest of a drug dealer, and they just say that whoever's living there with them is a member of their family. This may be unduly restrictive for them because it's where they're living in Vermont, but it's not their domicile. And then there might be some evidence that comes up in the investigation that might unintentionally sweep the situation and preclude derivative proceeds at our primary residence from being seized. So that's in flux, to be quite honest. And if we scroll down, this is informed by new subsection C, which largely remains unchanged from the previous version with the exception of the amounts that were discussed. Under subdivision 2, the US currency has been up to $2,500 or less and excludes drug buy money from that computation. So that, you know, when law enforcement uses controlled drug buy money, that can't be counted towards the amount that is precluded from seizure. Also in subdivision 1, homestead real property, there was discussion from the committee last time about the limitation of $125,000. This sort of goes back to discussion of primary residence. There was a lot of discussion about should it be domicile, should it be primary residence, and the consensus among law enforcement folks is that homestead real property might actually be cleaner. And the reason why is, you know, let's say you have a home that's valued more than $125,000, may be seized, but through the process, the person could get the $125,000 back. And you know, and again, it's trying to be considerate of law enforcement's investigatory realities.
So using the term homestead avoids, it makes it clear it's a homestead, it's not a second home, for example.
Right, it would be the person's, you know, the homestead of a natural person, so their dwelling house with living, but it's capped at $125,000.
If somebody has a camp up on Sucker Pond and that's where they're doing their drug deals from, or making meth or doing whatever, that could be seized because it's not a primary residence.
Yeah, it could potentially be seized, you know, and it's all dependent on sort of the facts of the investigation.
Yeah, no, I'm just trying to make sure I understand the homestead.
And so moving on, a motor vehicle, that value was up to $10,000 or less in market value. That seemed to be a consensus amongst, from the testimony previously.
Yeah, with inflation, that.
Subdivision 4 remains largely unchanged. Subdivision B was clarified a bit, that the Attorney General shall provide advice instead of just advise on the publications. Moving on to section 4242, which is on page 3. This section largely remains unchanged from the current law, with the exception of clarifications as far as language of preliminary order of process and the order of process in line 6 and 7. There was the removal of there was discussion sort of over the temporary seizure. There's removal of that altogether to just basically have the case law as it currently is to dictate the situation during the investigation. Subsection C on page 3, starting in line 17, keeps in the addition that when the state intends to seek forfeiture. So when property is seized without process, and there are those exceptions under D1 through 3, just above subsection C, that the state does not have to seek a preliminary order or process when it's seized without it, unless it intends to seek forfeiture. This was brought in to essentially give law enforcement the ability to conduct the investigation it needs, because it may seize property that it doesn't make sense to seek forfeiture on. There are other investigations, other crimes that it may be related to, and so this only starts the process where they would need to kind of bookend by getting that order when the state only intends to seek forfeiture after the seizure. There are no other changes to that section of the law. Changing to page 4 under section 4243. This largely remains unchanged from the previous version, from the House version of the bill as well. It still says that conviction or agreement is required to forfeit forfeit property, and that's if a person is convicted of a crime. The state may establish by clear and convincing evidence that the property was an instrument or represents the proceeds of the underlying offense. Subdivisions 2 and 3 provide that an agreement is required. It could be a plea agreement, it could be some other form of immunity agreement, even a pre-charge potential diversion agreement. And this, gives the state the ability to seek forfeiture of the property even before a criminal charge is filed, if an agreement is struck contemplating that.
In line 10, struck out the word or, line 13 would add the word or.
Yeah, because subdivision 3 was a new addition in the House version of the bill. Basically just to contemplate immunity or reduced punishment agreements that may be had without the filing of a charge. So if someone during the investigation, a witness is, or someone that maybe has some criminal culpability, it gives the state the ability to strike an agreement with them without having to bring a criminal charge first.
So striking out the word on line 10, does that mean that both 1 and 2 have to be the same, or are they considered to be mutually exclusive?
Well, it provides separate bases for them, so I don't think that they have to be mutually exclusive. It's just different bases for different agreements. So that it wouldn't have to be an and. It wouldn't be that someone's convicted, they enter into a plea deal, and that they would.
The forfeiture procedure can take place if, one, there is a criminal offense related to the action and the state establishes that the property clear and convincing evidence. Number 2, it could be if there's a plea or other agreement. Number 3, if the state grants immunity or reduced punishment, you can still seize property.
Correct. Yeah.
So that could be part of the immunity or the plea agreement that they would lose the $25,000. I keep using that as an example. Correct. Because that's the feds don't take anything less than 25,000. Is that correct?
I'm not. I can't say
Well,
what
no,
it
it
is.
doesn't matter. But I thought that's what it was. Anyhow.
But yes, that's a good way to look at it.
Okay, so any of those factors, you could still have property forfeited.
Correct. Okay. Moving on, subsection B and C remain unchanged. This just says that the state may introduce evidence of a conviction into the forfeiture case, and the burden of proof is that the state has a clear and convincing evidence standard that the property was an instrument or represents the proceeds of the related offense. So subsection D concerns notice of the forfeiture process and of the seizure. So what has changed here is that within 60 days, rather than from the seizure occurring, but from the preliminary order or process being issued. And what that does is to account for investigatory reality. So that once that order is issued, that kind of bookends a seizure, then the clock starts to run for the state to notify a defendant, owner, or lien holder. And if you'll see on lines 2 and 3 here, the language has changed in the sense that possessors are no longer included in the people that are notified. And this is a result of discussions with the other interested parties that it's really difficult to identify who is a possessor of property. Owners and lien holders can be identified through the search of public records, but possessor is sort of this squishy term that, technically it could be, and we talked about the girlfriend of an owner, but you don't necessarily know and you can't readily ascertain who's a possessor. So this change accounts for that reality and sort of the impracticality of identifying those people. And it continues on to read that those people are notified if known or readily ascertainable after a reasonable search of public records. And so it just provides that direction to say, this is how you can identify them. And this provides an extension of up to 30 days for good cause for the state to file that notice if for whatever reason they need it. Subsection E remains the same from the House portion. This is just return of property. So if notice is not sent in accordance with subsection D, the property must be returned. However, it does eliminate lines 10 through 12, which basically says that the state has one bite at the apple at this. You can't kind of do a do-over. But this remains unchanged from the House version. Subsection F talks about the filing of the state's petition for forfeiture. And so what this does now is provides the state up to 90 days, which is a change from 14 days after the preliminary order is issued to file the petition of forfeiture. That change again is to account for a decision to really seek forfeiture on the part of the state. That they may, 14 days can be a tight turnaround to really make that decision. And so this was bumped
Quite a
up
jump.
after that.
Quite a jump.
Yes, it is a large extension of time. And again, on line 18, it's just indicating that this petition is filed in the criminal division. So while this is a civil case, it's all being heard by the criminal court. So it's in the same courthouse. And again, that's good to keep in the back of your minds in the sense that these can be parallel processes and mechanisms are worked into the structure to permit that so that there aren't unintentional defaults or it's not hard to track the civil case and the criminal case at the same time. Subsection G on page 6 is the service of the petition. The lead-in language remains unchanged, so the petition must be served in accordance with Rule 4 of the Rules of Civil Procedure, and the state must publish the notice in a newspaper of general circulation as ordered by the court. That remains unchanged. However, the petition itself, lines 5 through 12 have been removed, and a new subsection H, which describes the form of the petition itself, is added. And this is a new addition from the House version. And this is, again, akin to that package of materials that a driver may receive on the roadside during a DUI stop. So what this does is it describes the petition that the state must make out. So it will include an explanation of rights, the facts upon which forfeiture is requested, which includes a description of the property, the type, quantity of regulated drug involved, the names of apparent owners, lien holders who have properly recorded their interests. In the case of a conveyance, like motor vehicle, name of the person holding title, the registered owner, make, model, and year. The petition shall also include a civil complaint form and a form affidavit for a person to demand a judicial determination of the forfeiture. This is to make it easy for them to do if they so choose. Because it's later outlined in the statute that it needs to be in the form of a civil complaint, it needs to be supported by a sworn statement. So these forms will be provided to the individual with the petition. It will also include a form to request a prompt post-seizure hearing. This will include in bold-phrase print, essentially a recitation of rights, bringing attention to them, that the person has a right to ask for a prompt post-seizure hearing seeking return of the property, that if you do wish to request a hearing before the criminal division, you must mail or deliver it within 7 days. So they have 7 days to make the decision on a prompt post-seizure hearing. If the request is not mailed or delivered, you waive your right to that hearing.
Is it 7 days from the delivery or 7 days from the mail?
It would be from when they receive it,
From what?
from when it's received. And when you see here the parentheses dated petition, that will be supplemented in reality with whatever the date is that the petition is printed or mailed. And again, this is derived from the civil suspension summary procedure, which this form and the way it's drafted is very similar to that. So it's not unprecedented. And again, C, waive the right if you don't file it, and in order to request it, you must sign the form and mail and deliver it to the court administrator at the address that's provided. So those are the forms. Subsection I is the exceptions to the conviction or agreement or requirement that was discussed earlier, whether there's a conviction, a plea agreement, or an immunity agreement. So basically this says that forfeiture can be pursued without those requirements when and so that there's upon a motion by the state, those requirements may be waived and title can be granted in the state. So the state must file a motion with the court not fewer than 90 days after the preliminary order or process is issued to prove that by a preponderance of the evidence before conviction, a defendant, owner, or co-owner of the property was either deported, they fled the jurisdiction, or they abandoned the property. So basically, those are the exceptions to the conviction or agreement requirement. If they were deported, if they left, or they essentially abandoned the property altogether, the process still has to play out through a motion, but it's an exception to the agreement or conviction requirements. And I should also say that this language is still a little bit under discussion with the Department of Public Safety and the state's attorney and sheriff's office, just to ensure that that there can be the title can be gained in cases where a drug-related offense isn't necessarily filed, and once again, kind of permit that investigatory process to play out.
I'm getting a little nervous. You keep saying that this is still under discussion. Tomorrow's our final day, and I don't know how much longer you want to be under discussion. But hopefully, in the next 24 hours or less, I say the next 22 hours, we can finalize our discussions.
And yeah, and to be frank, you know, I don't want to speak on behalf of the department or the state's attorney and sheriff's office, but you know, there's a lot to do to create this process to make sure it's right, and to do it only in a few weeks.
Here's the problem. Okay, I want to be clear. I want to do this, Bill. I want to do it right. When this came over here, I was told that this was an agreement, that the Department of Public Safety bought into it, that everything was fine, and that this was just going to get rubber stamped. That's what I was led to believe. Clearly, that's not the case. So I need to know what, you know, I don't know how much more time we have, but I do know that we may meet on Wednesday morning. You know, I'll be virtual, but Wednesday morning at 8:30, that we could fit something in if they could finish it by then. But there's no, after that, if it doesn't make it, it's coming back next year. So just for the witnesses and all of you, I don't like doing this to you folks, but I'd like to finish this tomorrow.
I think that's reasonable.
Yeah, and you know, again, I will continue to work with everybody that's been working with me so far to try and get this done. I just, again, I don't want to speak on behalf of them, but just from what I understand so far is that to kind of get to fully analyze this in a way that they can get that, it can be signed off on. It's
Fair
just a
enough.
tight time.
But hopefully tomorrow we can deal with it. I'm putting up a new agenda package to work on.
I was gonna say, when do you want?
Well, that's the when. And obviously the lawyers need to be available. So go ahead.
So moving on to subsection J on page 8, This essentially is a default provision. It says unless a timely request is made for a post-seizure hearing or for a hearing for judicial determination, the court shall enter default if it's not filed within 90 days of the after the state's petition has been filed.
So when will we ask questions later? So,
Sometime today, between now and 11:45.
Okay, well, if there are no questions right now, I'll move on to 4243A, which is the prompt post-seizure hearing. This says essentially, subsection A, that you have a right to one within 7 days of receiving the notice. And then this language was worked on quite extensively, but basically a defendant, any family member or domestic partner of the defendant who are regular users of the property, any owner of the property, any of their family members or domestic partners who are regular users, or any lien holder. And the reason why this language was used here, as opposed to the notice portion, is because it's hard to identify a lot of these people on notice. But if these people become aware of the action, either through looking at the newspaper or in another way, they have the ability to petition the court for the seizure. And they will have the burden essentially to prove the validity of their interest. Regular user was previously discussed the last time this was taken up as being sort of an inherently squishy term, and to a degree it is. But this was refined to say that it can't just be any family member that says that, if you have a long lost uncle that for whatever reason wants to claim ownership of the property, it has to be someone that really has a regular use of it. So it really contemplates that the person coming to court has the burden to show that, yeah, I live with the person who the property was seized from, and I use it every day to get to work. So that's their burden to show, and it prevents or attempts to mitigate the concern of the long lost uncle, so to speak, coming into court and trying to gain possession or ownership of something. So subsection A gives the people the right within 7 days of receiving the notice of seizure and forfeiture to seek a prompt return of their property. And what it does is that they have to mail it or deliver it to the court administrator of the county in which the seizure occurred, who shall notify the state that the hearing is requested. Subsection B.
May I ask a question about that? So it says within 7 days following the service, but these people aren't going to get service. So how do they know when the 7 days? They read it in the newspaper. That's how they find out, because they don't receive the service.
Mm-hmm.
So they have to still do it within 7 days of looking in the newspaper, or where does this 7 days apply?
Yeah, and that would be the intent, but I think, this is language that probably should be maybe a bit more precise to account for that situation.
Yeah.
So thank you, Senator White. But yeah, that would be, essentially once they become aware.
Yeah.
So maybe it could be worked in that 7 days after publication as well.
and is it business days or? Yes.
Seven is the way we've always been told in Gov. Anything under 10 is business, and over 10 is calendar.
How's everybody gonna know that?
I don't know, but that's what, so
Well, I thought
I
we
think
did-
it's really better to specify.
Recently, the one that was, the one we just did. on
And we said business,
We said business.
yeah.
which makes
It's
more sense.
always best to say business
I
or
agree.
calendar.
Absolutely.
Because people don't
People
understand.
would never
that.
understand that, so should we say that here?
That could be added. Want to specify that it'd be business days.
Yeah.
And there's another section at the beginning where it
That's not one I
specifies.
Well, that could be added throughout.
Yeah.
And so going on to subsection B, which is on page 9, this discusses the procedure for the hearing. It will be procedures that are prescribed by the Supreme Court. The hearing is conducted without a jury. And then unless it's impractical or for good cause is shown, or there's an agreement between the parties, the court shall hold the hearing as a separate hearing at the same time as some post-arraignment hearing, a probable cause determination, or other pretrial hearing, or at the same time as a hearing related to a Rule 41 hearing, which under Rule 41 of the Vermont Rules of Criminal Procedure, that any person that's an owner or who's been aggrieved by the seizure can petition the court for return of the property. That is a separate procedural process that there, and it doesn't have to be related to a criminal action. So again, this is an attempt to basically give the court discretion to schedule this in the way that makes the most sense for the court, and give it the flexibility to do that. And I should say that this has not gone through editing yet, so there may be some small issues which I've just identified on line 13. There's subdivision 2, which should be a different, should be a subdivision 4. But this outlines the return of property, so that if the court finds that that the seizure was invalid, that a criminal charge has not been filed, no probable cause exists to show the property is subject to forfeiture under the subchapter, or that it's not reasonably required to be held as evidence, the court can give the property back. Again, this discussion, or this section, is under discussion a little bit with the interested parties, so it may be further refined. Subdivision 3, which will be redesignated, so that upon determination that the property should be returned, the court has the ability to impose conditions, including use of photographic evidence, basically so that the state could still use it for evidentiary purposes without possessing it. So it gives them the ability to use it if there are other proceedings that are ongoing. 42, 44, the forfeiture hearings themselves. So again, subsection A provides the right for a forfeiture hearing. So within 60 days following service of the notice of seizure and forfeiture, which I think will add the publication language and the business days to that from the previous section, that a defendant and those other individuals that we listed, the family members or regular users, or lien holder, may file a demand for judicial determination of forfeiture. So this says essentially, can the state actually take title to this? This gives these people the ability to say, no, you know, I dispute this. I should be able to gain ownership or keep ownership of this property. And again, this outlines what was outlined in the form of the petition earlier, that the demand must be in a form of civil complaint, sworn affidavit that sets forth the right, title, or interest in the property, a request for a return of the property, or a compensation equal to the interest in the property. And then the facts on which the claimant relies upon, and any non-criminal source of the asset or currency at issue. And it must be filed with the court administrator in the county in which the seizure occurred. Subsection B, C, and D outlines the defendant's forfeiture hearing, the lien holder's forfeiture hearing, and the innocent owner forfeiture hearing. Under B, which is for the defendant, that the court shall not order forfeiture of the property if a hearing is requested by the defendant in a case related to the criminal offense underlying the forfeiture action. The court shall hold the hearing as soon as practical, but not later than 90 days after conclusion of the criminal prosecution. So the criminal case needs to be wrapped up before the forfeiture case can be heard for the defendant. The lien holder under subsection C must make a request again, and the court shall hear the petition within 90 days of its filing or as soon as it's practical. So it's not dependent on the underlying case being wrapped up. And then the lien holder has the burden to show by preponderance of the evidence that they have a valid good faith interest in the property, and it wasn't held through a straw purchase trust or otherwise for the actual benefit of the other. So it needs to be a direct interest. And then also the lien holder did not have knowledge or reason to believe that the property was used in an unlawful way, and that the court has the option to either order return of the property or compensation of the lien holder to the extent of their interest, whichever is of less cost or expense to effectuate.
Thank you.
The innocent owner hearing, you scroll down to page 12. Again, forfeiture is not ordered. If one of those interested parties that we discussed earlier requests a hearing, the petition again shall be heard within 90 days of filing or as soon as it's practicable. The court again has the ability to hold the hearing in its discretion as a separate hearing or at the same time as a Rule 41F hearing. And the court shall order return of the property if the requester, who has the burden to show by preponderance of the evidence the validity of their ownership interest or regular use, and that they did not consent to or have any express or implied knowledge that the property was used or intended to be used in a manner that would be in violation of the law, or that the requester had no reasonable opportunity or capacity to prevent the defendant from using the property in the way that was unlawful. In subsection E, it just discusses the nature of these proceedings, that they are civil in nature, they're conducted without a jury, and that the state has the burden of proving all material facts by clear and convincing evidence, and that would be to prevail on the petition. Subsection F outlines what the court must do. They must make findings of facts and conclusions of law to issue a final order. If the state's petition is granted, they can order that the property is held for evidentiary purposes. It can be delivered to the state treasurer, or it can be destroyed if the property is considered harmful to the public. If the demand for judicial determination made by one of the requesters is granted, it gives the court the ability to impose reasonable conditions to essentially preserve access if there are any other proceedings in a criminal court. Subsection G is added to provide an appeal, that it may be appealed as a matter of right, and that the forfeiture shall be stayed pending the result of that appeal. 4245 largely remains the same from the House version, but what the House version did is that it changed remission or mitigation of forfeiture from it being a court dictated process to giving the state's attorney the discretion to do that. So what that does, and again, it remains largely the same, is that upon a request by one of those interested parties that we've discussed, that is made at any time before the criminal division enters judgment in the related case, a state's attorney may agree that property seized pursuant to this title can be remitted, so given back, or mitigated. So, essentially maybe some cash can be given back. It needs to be a sworn statement, needs to include all necessary information. The state's attorney can investigate and hold an interview if it's appropriate. And the state's attorney shall approve or reject a request within 30 days. That time period may change as well based on the discussions with the law enforcement folks, and the reason why is that there may be a lot of requests for this, and so maybe 30 days may not be a long time. So the 90 days that it was originally in statute may still be there. Under subsection B, it gives the state's attorney the ability to remit or mitigate upon a finding that the requester has a valid good faith interest. That's direct. And that again, the state's attorney can, if they do approve the request, they may file a request for the court to impose those reasonable conditions to preserve access to the property if it's necessary in another proceeding. Section 4247 is the disposition of property. So how property, once it's sold, how it's disposed. Subsection A remains unchanged from the House version. Subsection B, the lead-in language remains unchanged. However, subdivision 1A and 2 changed. The amounts have changed from 45% going to law enforcement to 80% being distributed to them based on their proportionate participation in the investigation or in the prosecution. The remaining 20% would go to the general fund. The reason for this change is that based on discussions with law enforcement, part of the overall impetus for this bill is to create a workable system that law enforcement and prosecutors would use in the state. The federal system has an 80-20 distribution of funds. So this essentially provides another incentive for law enforcement to use the system so that after restitution is paid to the victim, costs of storing the property, after everything else is paid, then the remaining 80% is distributed to the AG, state's attorney, or local law enforcement based on their participation.
And just a historical context, I think back when we redid the forfeiture laws, that this is based on before the House changes. We ended up in a conference committee over this, and I believe the Senate was at 75-25 at the time, and I could be off by a percentage or two. And the House was adamantly didn't want to do any more than 45 because they felt it would encourage the different times, different stages, but I do remember the discussion, and that was a bone of contention at conference way back whenever we did this the last time. I don't know what it was. So anyway, I'm willing to go with 80, but there'll be that argument. Committee wants to change it to a lower number. We can hear.
I'm concerned about the conflict of interest that the Attorney General has here.
Oh, yeah, you're going.
They decide who gets the money, and they're one of the people who would benefit from it.
Yeah, and in that subsection or subdivision 1B, that was a difficult question to answer over who is sort of the determining body.
Right.
Because the Governor's Criminal Justice and Substance Abuse Cabinet no longer exists. Based on the prior testimony of the Office of the Treasurer, they did not want the responsibility. I've inquired with the Attorney General's office if they've had, and Senator Benning, I believe you mentioned last time that they may have done this in the past. That's still being found out.
Yeah, they did have a designated individual. I don't know if that position.
Hired by them, hired in the AG's office.
These officers are going all around the state doing forfeitures of automobiles and DUI cases.
What is the House version?
The House version was the state treasurer.
She doesn't.
She doesn't want to hear
And this was in my discussions with the state's attorneys and Department of Public Safety. This was, another reason why the federal system is used, because they have not just a criminal and civil process, but they also have an administrative process that really streamlines this. And they have an administrative branch, essentially, of the judiciary that can do this quickly. And so
Maybe it should be the Secretary of Administration.
I was thinking I was trying to think of somebody who's completely impartial to any of these.
Well, the Secretary of
Agencies, and that would be,
Administration is in part,
Yeah.
we'd have to make sure. We should notify them before we give them the duty, but Secretary of Administration, basically is the Division of Finance and Management. They're going to, they do set budget and so forth for all of these agencies. So,
Except local ones.
except local, but they do. I would think that they'd be more impartial.
How much of forfeiture, how much of a burden is this? Is there tons and tons and tons of forfeitures that happen every year? I thought we were told that there isn't very much.
well, currently, based on the testimony, this is rarely used.
Right.
And
That's what Mike Smith just said from the Department of Motor Vehicles. He was here on another matter, but he said he's only been looking for 2 vehicles.
Right, and that's part of the reason why this version of the bill is the way it is to create it so it is workable and it does incentivize use so that it's kind of a cart before the horse question. You don't really know the problems that exist if the process isn't being used yet. So part of the design here is to incentivize that use to then potentially highlight some issues that could be addressed later
I
on.
apologize to all of the witnesses that are here to help us with this. I do thank you all for your work on this, but we got 5 minutes left. You can take that down now. I think well, actually, there's another page.
Well, there's another page, but basically it's just a 20%. There's a title change that's proposed, and also the limitation on federal adoption has been completely removed from the House version. And that was the one that would restrict the federal government to come in and adopt seizures and put them through the administrative process for amounts that were below $25,000. It did not preclude task force use, but after my discussions in the previous testimony, again, to make this a workable, useful system, the removal of that limitation is going to facilitate that.
So.
Maybe the auditor.
We could ask the auditor, but I don't know that it's an appropriate role for the auditor. Because they'd have to audit, they audit the sheriff, for example, they audit.
Yeah.
I just think Secretary of Administration might be the most logical.
Or maybe the chair of Senate Judiciary.
The what?
The chair of Senate Judiciary.
That could be another one, yeah, I'd be happy to do that, as long as I'm chair. As long as I get.
Everybody else doesn't do that.
Well, I'm happy to, I'm happy to inquire with Secretary of Administration to see
Would you
something.
please? Any quick comments from anyone before we move forward here? Is there anyone who's adamantly opposed to this version?
We're not adamantly, but I'm nervous about whether it's prime time.
We have serious concerns about this version. We'll be prepared to discuss them whenever there's testimony, but we do have serious concerns about this version still.
Okay. Well, we'll do our best tomorrow to take it up. Hopefully Ben is available at 10:30.
Yeah, I sent you a request.
And we'll take it up at 10:30 and hear from those of you who worked on it. But I'm telling you right now, we don't have a lot of time. Ben and all of you who worked on this, my appreciation, sincere appreciation. The next agenda item.
Mr. Chair, I'm going to need to drop off and drive down there,
Okay,
but I will,
Drive carefully.
yeah, I'll see you all on the floor.
Okay. Thank you for doing that. Yeah.
okay. So this is S-254, also known as an act relating to the report on qualified immunity. And this is, we concur with further proposed amendment. And it's the record of case dispositions.
May I ask a question about this? Came up late yesterday.
Sure.
The question was, is it all, this is just final judgments that are actually court claims, but do we want to know ones that are settled before they actually get to court? That was just a question that came up, and I didn't know what the response was or what we thought about that.
Yeah, and I toyed with the language a little bit where I added court claims to that to try and get to those external complaints, but I could also add that it would not, that this shall not apply to essentially internal complaints that would be governed by.
Yeah, no, that I get, and I appreciate that. But what I meant was, I thought we heard that there are some claims, I'm gonna sue you, Montpelier Police Department, and then we settle before it ever gets to the point of getting to court. And do we want to know those settlements also? That was the question. wasn't that the
I
question?
asked that question, how would you know about them?
So
Yeah,
essentially, if there's a demand letter that's provided to the department saying that unless you pay, we'll sue.
yeah, and I don't know I don't know that there's any way of even, I don't know that at all, but that did come up. And so I'm fine with this, but,
So are those included? If there is a demand letter, they would be, is that what you're saying?
Well, for this, it would just be claims that didn't make it to court,
This is just claims that didn't make it to court.
that do make it to court. You know, I think the
Just
intent is that it would be any claims that would be paid out, but it's not explicitly.
These are just do make it to court. And you might settle, goes to court, they settle out of court, but that would at least be on their records.
Okay. Everybody okay with this?
we, without Phil here, I'm not sure if we have.
The votes.
And just as a point of information, in the previous bill, this was part of a new chapter that was added. That's not being done here. This is being added to chapter 151 of Title 20, which concerns the Vermont Criminal Justice Council. So while it's not directly relevant, it just seemed like the most sensible given the fact that it discusses a lot about law enforcement. And so, you know, it's included in that. So just for the committee's knowledge on that front.
How can we get rid of the line referencing an act related to a report on qualified?
What would you like to call
Doesn't he rename it here?
It is a long title though.
Well, you could say an act relating to maintaining records of judgments and settlements paid by law enforcement agencies.
Well, there's more to it. This is just the amendment.
Right,
There's
right.
more to that.
I know.
Yeah, because the report does
Yeah.
remain
And you changed report to legal analysis.
in this title change.
Yeah,
correct?
so
That's
this
what we
is,
want out.
I appreciate the fact that this has been radically altered from the first version, but I'm trying to understand the need. In fact, our previous discussion is statistics information. I can imagine them gathering some of this data as well. Just looking at the optics, trying to figure out how to explain it.
I know, there's no way.
Probably let's do it.
Well, I will move that we concur with the.
Senator White has moved, we concur with further amendment. Is there any further discussion? Okay. Peggy, please call the roll and then hold it open. Senator Burris.
Senator Penny,
No.
Senator Nika,
Yes.
Senator White. Yes. Here, Senator.
Yes. Oh, yeah,
Sorry.
you, yeah, okay.
So do I just wait till tomorrow and ask him? Is that what I do?
Well, no, you could, if he'd probably drop by.
Oh, okay.
He'll be here in an hour.
Okay, and I don't need to do anything
Make up
anyway. You did bring it up there.
Thing for this.
I have not, do you think it'll be heard today or it will be?
No,
It's on the calendar, but I have not,
But the calendar is very long.
yeah.
well, man,
265, I know is on as well. That's the,
Criminal threatening, canvas.
threatening, I'm ready to concur.
yeah, okay.
That'll only take about 3 minutes.
Yeah, there's a lot of unfinished business that are on the calendar today.
Well, I don't know. Yeah, if you can Well, prepare it anyway. We need to the committee vote anyway, so, yeah, we could do it tomorrow.
I can have it prepared for tomorrow.
Have it prepared for tomorrow morning.
What are you talking about tomorrow morning?
I'm here.
No, what are you guys talking about? I wanna make sure I have it on the agenda.
It's not on the agenda, we'll get a formal, the document to take upstairs tomorrow
Okay.
morning.
Okay,
Give it to the Senate Secretary.
okay, so should I end this live stream now?